So now the legislature has deleted transport vehicle part and has just light motor vehicle, adapted vehicle, medium or heavy goods or passenger vehicle as transport vehicle. And then explanation, my lords. Non-transport vehicles include motorcycle with or without sidecar for personal use, mopeds three-wheel for personal use, motor car for personal use. Transport vehicle includes a public service vehicle, a goods carriage vehicle, an educational institution, bus or private service. Light motor vehicle includes, and it has been substituted, the transport has been done away with in this part. Would read, my lords, transport vehicle, which is there in the definition, that in the form has been done away with now. This amendment, my lords, is in 2021 though. So the legislature itself has clarified that light motor vehicle includes omnibus, the gross vehicle weight of either of which, or a motor car or a tractor or road roller, the unladen weight of any of which does not exceed 7,500 kilograms. Then medium goods and heavy goods vehicle are there. Interesting, if your lordship sees others also, which is not covered in any of the above categories, includes harvester, excavator, forklift, trailer, crane mounted vehicles, agricultural tractor, power lift, tow trucks, breakdown and van recovery vehicles, construction equipment vehicles. A 5 at 687 says, my lords. In case of request for addition of a class of vehicle in transport category, please fill the following: enrollment number in the driving school, enrollment date, etc. That they want to drive a transport vehicle. Because for transport vehicle, as your lordships remember, the section itself says that you should hold a license for an LMB for 1 year. So you've applied for LMB, and therefore the addition now comes that you want to apply for a transport vehicle. So on my own, I can't go on my 20th birthday and apply that I wish to drive a transport vehicle. That is not the scheme of the Act, Milords. It presupposes you have at least for 1 year driven a light motor vehicle, and then you will have an addition of a transport vehicle. This Form 2 has been dealt with at considerable detail, my lords, in Mukund Devangan. And my lords, is Form 5, etc., which really I don't think I should take your lordship's time.
Mr. Dave, there's one aspect which we have probably not cited.
Yes,
you
my
see the syllabus.
Yes, my lord.
Which is the syllabus for imparting instructions in driving of motor vehicles.
Yes, my lord.
Now 31J.
Yes, my lord.
The training for light motor vehicle driving is one. This is the syllabus.
Yes, my
Then there is a separate syllabus for medium and heavy. And thereafter, there's another syllabus for two-wheeler driving.
Yes, my lords.
Now, these training institutes have to be provided a certificate.
Yes.
This certificate is to be issued in Form 5B.
Yes, my lords.
Now, this is to be as per 31II.
Yes.
31EII.
Yes, my lords.
Now, if the training is identical, the certificate issued is identical, and this is the certificate on the basis of which the license is to be applied for.
Yeah.
And what would be the import of these provisions?
Lordship pleases. My lords, in the table that your lordships are seeing, the table, the first one, since it says what is to be done by a non-transport vehicle in 31(2), covers part A, B, C, F, G, and K. 31(2), if your lordships sees, my lords, the lessons for training drivers of non-transport vehicles shall cover parts A, B, C, F, G, and K of the syllabus to sub-rule 1. and the training period shall not be less than 21. The lessons for training of drivers, vehicles, transport vehicles covers E, F, G, H, I. So when applying for a transport vehicle, I have already undertaken A, B, C, F, G, and K in my examination. Thereafter, my lords, when I'm taking for transport, then I will cover parts E, F, G, H, I, J.
So there is
and
an additional training.
There is an additional training, that is, which is 1 year after, and for a specified period of, it says 30 days, 21 days then for transport, I have to undertake a 30 days further training.
It covers E, F, G, H, I, J, and K.
K is important, my lords, because K, I think, deals with first aid, if I'm not mistaken. E, F, G, H. I is fire hazards, vehicle maintenance. K is first aid. So K being suitable for human life, my lords, if some accident takes place or one injures oneself while driving, so K becomes first aid. So the statute requires, or the rules require, that you undergo that training again as far as first aid is concerned. K is common, my lords, and public relations for drivers, G, is common. So like F, which is transport, traffic education. Medium and heavy vehicles, that is E, theory 2, transport. And that's why in C, your lordships will find, it will say light vehicles driving practice, which applies for LMB.
So, Mr. Dave,
Sorry.
perhaps we can say this.
Yes.
All those who are holding an LMV license,
Yes.
if they look at a truck driver,
Yes.
they must understand that he's better educated, at least from the license perspective.
Yes. Most certainly. At least.
Isn't it?
Yes. That assumption is there. If
Language, first aid, so many things he has to learn.
on a principle,
I don't think you are learning all that with your LMV license.
I don't think that way. On a ceteris paribus principle, because everything else remaining the same, a bus driver or a truck driver in this is certainly more educated than me when I'm driving a.
But this language is interesting. We always thought truck drivers need to learn certain kinds of language, but that is not what it is talking about.
That language is excluded.
Yeah.
Transport language.
Transport language.
That is excluded.
It's tough language. Difficult language.
In fact, they are better in.
Because if you lordships just sees the drive, though all of us ordinarily hold a driving license, at 881, which is Form 7, which is the form of driving license, they even provide to that much detail, laminated card without chip or smart card, visual inspection. It has, my lords, at 882, motorcycle with gear. It has class of vehicle, motorcycle with gear, LMV, which is shown in a car, transport as a category, and then motor vehicle of specified description. Non-transport, specified description. And I'm informed of vehicle category, it will say NT is non-transport, TR is transport. So LMV, NT, TR, transport, and NTTR, there's a specific endorsement that has to be made there in the licensing category where what vehicle is being driven. Page 882. So transport, even if it's LMV, it will say non-transport or it will say LMV transport.
Where is it in 882?
Lordships has that where motorcycle and all are made on the left side, my lords.
Yeah, this one.
Yes, car.
Car hai, choti si.
It's the last bookmark, my lords, forms.
Column 11.
Gives out those pictures, that kind of picture of a driving license. So my learned friend's original compilation, the SEC didn't have it, so therefore he's added it later. So that not something is not missing. This is important.
Personal symbol mentioned.
Now there's the oblique.
Yes,
Is it and or is it alternative?
it's alternative.
Oh. NT, is it? Oh, I see. Does any of the juniors have a license here? I didn't want to ask the seniors to do that.
Your junior is.
Anyway, his is valid only for
My learned brother has one, surely.
I'm saying his junior is here.
To date,
You are entitled to drive both.
non-transport. Military transport is different, yeah. Oh, it says validity non-transport, you're right. Validity.
was mentioned.
License without this, two distinction.
Yes, my lord. It may be.
Perhaps the licensing authority read the SCC version instead of.
No, that has come by way of an amendment.
That's right.
Before that, there used to be an endorsement. I'll show the old form also.
Exactly. Yeah. Gadi ka hai?
LME.
And then non-transport.
But
This actually puts it beyond the pale of doubt, actually.
that's why I'm saying. I can take your lordships to Mukund Devangan.
In fact, it's exactly like the same
Same form.
form. Form is actually printed on the card. Same form. See inside.
I can imagine. my lord.
Let's see that.
It has to be.
Has to be, yeah. Now,
Same act
that's a
applies.
good thing, it's nationally unified now.
Yes.
This form has come in 2019. The earlier form had a separate plot thing saying
just
that endorsement for driving a transport vehicle.
Sure.
This as being the same person as the holder of the license. He doesn't have your beard anymore. Oh.
I thought, why did Mr. Sood need to go to Tamil Nadu to get a license? But this is below the belt. That's it. Aadhaar, driving license, passport pictures are not to be shared.
And passport pictures are particularly bad because, the person who takes the photograph is constantly making you focus on that both your ears must be visible. Then, you must look in a particular way so that the reflection doesn't come in your specs.
Glasses, my lord,
Or no glasses. In the olden days, at least, that was
Wear glasses, it's so difficult
Yeah.
because if I take it off, I can't view even the court master clearly. Because that old form which Mr. Bhushan would place, my lord, it's there at page 880.
880.
880.
When did this new form come in?
2019, Mr. Bhushan. Well, the form itself starts at 878. And at 878, your lordships will find right at the bottom of 878, transport vehicle, light motor vehicle, road roller, etc. mentioned. And a motor vehicle of a specified description, namely the license to drive a motor vehicle other than transport vehicle at page 879 is valid from so and so to so and so. License to drive transport vehicle or e-rickshaw, e-cart is valid from this date to this date.
So even before the amendment, it was very clear that the license was to drive a motor vehicle other than a transport vehicle.
No, and just below that, your lordship will find
Name it.
authorization to drive transport vehicle. Therefore, the first two, LMV may be different from transport vehicle, but the second, the authorization to drive a transport vehicle may come on an LMV license.
Right.
Because earlier, my lord, that section 10 did not have transport vehicle separately till the 2000 and,
So, 94.
what, huh? 94 amendment. 94 amendment. Section 10 was changed in 1994 and transport vehicle came there then. But even earlier, section 3 said that you will not be permitted to drive a transport vehicle unless your license specifically authorizes you to do so. So at that stage, they used to make an endorsement on a light motor vehicle or a medium motor vehicle or a heavy motor vehicle saying that you are authorized to drive a transport vehicle.
Yes.
So I would assume, my lord, that all persons who hold a transport vehicle license can drive a light motor vehicles, but all those who hold a light motor vehicle license can't drive a transport vehicle unless if there is a specific endorsement.
Yes.
That is the scheme of the Act.
Yes, Mr.
Yes.
Does your lordships like to see Devangan? Because I'm done with the scheme of the,
Briefly, yes, let's do that because it's
Devasan and then we'll start.
it's the fourth bookmark, my lords, on your lordships' computers. My lords. Starts at page 56. After the head notes, my lord, it starts at 67.
Oh, yeah.
At page 67. In the reference, the main question involved is whether a driver who is having a license to drive light motor vehicle and is driving transport vehicle of that class is required additionally to obtain an endorsement to drive a transport vehicle. There is a conflict in the plethora of decisions of this court, and various decisions have been set out by your lordships, my lords, in the judgment. Then 3, my lords, paragraph 3. Following questions have been referred for decision to the larger bench. What is the meaning to be given to the definition of light motor vehicle as defined in section 221 of the Motor Vehicles Act, whether transport vehicles are excluded from it, and 2, whether transport vehicle and omnibus, the gross vehicle weight of either which does not exceed 7,500 kgs would be a light motor vehicle, and also motor car or tractor or a road roller, unladen weight of which does not exceed 7,500 kgs, and holder of a license to drive the class of light motor vehicle as provided in 10(2)(d) would be competent to drive a transport vehicle or omnibus, the gross vehicle weight of which does not exceed 7,500 kgs, or a motor car or tractor or road roller, the unladen weight of which does not exceed 7,500 kgs. The second question is more or less the definition of what is contained in 221. Then 3, my lords, what is the effect of the amendment made by virtue of Act 54 of 94 with effect from 14/11/94 while substituting clauses E to H of section 10(2) which contain medium goods vehicle, medium passengers motor vehicle, heavy goods vehicle and heavy passenger motor vehicle by transport vehicle, whether insertion of expression transport vehicle under section 10(2)(e) is related to said substituted classes only, or it also excluded transport vehicle of light motor vehicle class from the purview of Section 10(2)(d) and Section 241 of the Act. What is the effect of amendment of Form 4 as to the operation of the provisions contained in Section 10 as amended in the year 1994, and whether the procedure to obtain the driving license for transport vehicles of the class of light motor vehicle has been changed? There is conflict in the aforesaid decisions of this court with respect to the legal position as to pre-amended and also post-amendment legal position of the amendment made on 28/3/2001 in the forms of driving license. In order to answer the questions, it is necessary to consider the various provisions of the Motor Vehicles Act. Those provisions your lordships have already seen, my lords, but may only notice that there is in para 5, my lords, a reference to Section 3. It is referred to, and what your lordships are pleased to hold, my lords, are below the quoted part, that it is apparent from the provisions contained in Section 3 that it is necessary to have a license to drive motor vehicle in any public place, and in order to drive a transport vehicle, the driving license must specifically entitled him to do so. The question is, what is the meaning to be given to transport vehicle under Section 3? Then is the driving license Section 10 is set out, my lords, and the comment is para 7, that Section 10 deals in the forms and contents of the license to drive. Section 10, as it stood before its amendment made in the year 94 by virtue of Amendment Act 54 of 94, is extracted here under. This your lordships may kindly see. Every learner's license and driving license, except for driving, all that is same, my lords. Para 2 is the only, subclause 2 is the only part, my lords, where it went up till J, which is motorcycle without gear, motorcycle with gear, invalid carriage, light motor vehicle, medium goods vehicle, medium passenger motor vehicle, heavy goods vehicle, heavy passengers, road roller, and motor vehicle of specified description. So it went up with all these categories of J till J. And then, my lords, para 8, it is apparent from the pre-amended provision which existed before the amendment made in the year 94 that class or description of the vehicle for which license used to be issued were categorized inter alia as light motor vehicle, medium goods vehicle, medium passengers motor vehicle, heavy goods vehicle, heavy passengers motor vehicle, and motor vehicle of a specified description. Transport vehicle was not a separate class, and it could be categorized under sections 10(1)(d) to H. So anywhere from light motor vehicles to medium goods vehicle, to motor vehicles of a specified, or till heavy passenger motor vehicle. Sorry, Mr. The amendment has been made in Section 10 by virtue of the Amendment Act. The statements and objects of the reason of the Amendment Act being relevant is extracted hereunder. Statements of objects and reason. The Motor Vehicles Act 1988 consolidated and rationalized various laws regulating road transport. The Act came into force with effect from 1/7/89, replacing the Motor Vehicles Act 1939. After the coming into force of the Motor Vehicles Act 1988, government received a number of representation and suggestions from the state government, transport operators, and members of public regarding the inconvenience faced by them because of the operation of some of the provisions of the 1980 Act. A review committee was therefore constituted by the government in March 1990 to examine and review the 1980 Act. 3. The recommendations of the review committee were forwarded to the state government for comments, and they generally agree with these recommendations. The government also considered a large number of representations received after finalization of the report of the review committee from the transport operators and public for making amendments in the Act. The draft of the proposal based on the recommendation of the review committee, representations from the public were placed before the Transport Development Council seeking their views in the matter. The important suggestions made by the Transport Development Council relate to on or off or on account of A, the introduction of newer types of vehicle and fast increasing number, both commercial and personal vehicles in the country, providing adequate compensation to victims of road accidents without going into long-drawn procedure, protecting consumer interests in transport sector, concern for road safety standards, transport of hazardous chemical and pollution control, delegation of greater powers to state transport authorities, rationalizing the role of public authorities in certain matters. F, the simplification, since it's italized, I'll read that. The simplification of procedures and policy liberalization in the field of road transport and enhancing penalties for traffic offenders. Therefore, the proposed legislation has been prepared in the light of above background. The bill inter alia provided for modification and application of certain definitions of new type of vehicle, simplification of procedure for grant of driving licenses, putting strict restrictions on the alteration of vehicle, certain exemptions for vehicles running on non-polluting fuels, sealing on individuals or companies' holdings removed to curb Benami holding, states authorized to appoint one or more state appellate tribunals, punitive checks on the use of components that do not conform to the prescribed standards by manufacturers, and also stocking sale by traders, increase in the amount of compensation of the victim's hit and run case, removal of time limit for filing of application by road accident victims compensation, punishment in case of certain offences is made stringent. K, a new predetermined formula for payment of compensation to road accident victims on the basis of age income, which is more liberal and rational. The Law Commission in its 119th report had recommended that every application for a claim be made to the claims tribunal having jurisdiction over the area in which the accident occurred, or to the claims tribunal within which the local limits of whose jurisdiction the claimant resides or carries on business, or within the local limits of those for whose jurisdiction the defendant resides at the option of the claimant. Bill also makes necessary provisions to give effect to the said recommendation. Pre-amended provision of Section 10 contained the vehicles of 10 kinds in Sections 10(2)(a) to J. In order to simplify the procedure for obtaining the license category, like medium goods vehicle, medium passenger motor vehicle, heavy goods vehicle, and heavy passenger motor vehicle were deleted, and one category was inserted for these 4 kinds of vehicle in the form of transport vehicle in Section 10(2)(e), so that drivers are not required to obtain the license again and again for the aforesaid 4 kinds of vehicle. The provision of Section 10 after the amendment made by 54 of 94 is extracted here under forms and contents of license to drive. Your lordships have seen this. So F to H are deleted, and road roller and J motor vehicles of specified description are retained, and E is the transport vehicle category that is added. 11. Before dilating further, it is necessary to consider other definitions. Your lordships have spent considerable time on the definition, so I'm skipping that with your lordship's permission, my lords, and coming to paragraph 16. Prior to the amendment in 1994, license for transport vehicle was clearly covered as per Section 10(2) in 5 categories, that is Section 10(2)(d) in light motor vehicle, Section 10(2)(e) medium goods vehicle, Section 10(2)(f) medium passenger motor vehicle, 10(2)(g) heavy goods vehicle, and 10(2)(h) heavy passenger motor vehicle. The license for light motor vehicle has been provided for in Section 10(2)(d). The expression transport vehicle has been inserted by virtue of Amendment Act of 1994 in Section 10(2)(e) after deleting 4 categories or classes of vehicles, that is medium goods vehicle, medium passengers motor vehicle, heavy goods vehicle, and heavy passengers motor vehicle. Earlier Section 10 did not contain separate class of transport vehicle. 17 is important because the definition of light motor vehicle makes it clear that for a transport vehicle or omnibus, the gross vehicle weight, either of which are a motorcycle, motor car, or tractor road roller, the unladen weight of any of which does not exceed 7,000 kgs. Gross vehicle weight has been defined in 215. The motor car or tractor or road roller, the unladen weight of any of which does not exceed 7,000, as defined in Section 248 of the Act, are also light motor vehicles. No change has been made by the Amendment Act of 54 of 1994 in the provisions contained in Sections 221 and 10(2)(d) relating to the light motor vehicle. The definition of light motor vehicle has to be given full effect, and it has to be read with Section 10(2)(d), which makes it abundantly clear that light motor vehicle is also a transport vehicle, the gross vehicle weight or unladen weight of which does not exceed 7,500 kgs as specified in the provision. Thus, a driver is issued a license as for the class of vehicles, that is light motor vehicle, transport vehicle, omnibus, or another vehicle of other categories as per gross vehicle weight or unladen weight as specified in Section 221 of the Act. The provisions of Section 3 of the Act requires that a person, in order to drive a transport vehicle, must have authorization Once a license is issued to drive light motor vehicle, it would also mean specific authorization to drive a transport vehicle or omnibus, the gross vehicle weight, or a motor car, road roller, or tractor, the unladen weight of which, as the case may be, does not exceed 7,500 kg. The insertion of transport vehicle category in section 10(2)(e) has no effect of obliterating the already defined category of transport vehicle of the class of motor vehicle. A distinction is made in the Act of heavy goods vehicle, heavy passenger motor vehicle, medium goods vehicle, and medium passenger motor vehicle on the basis of gross vehicle weight or unladen weight for heavy passenger motor vehicle, heavy goods vehicle, the weight of which may be exceed, which as the case may be, exceeds 12,000 kgs. Medium goods vehicle shall mean any goods carriage other than a light motor vehicle or a heavy goods vehicle, whereas medium passenger motor vehicle means any public service vehicle, or private service vehicle or educational institution bus other than a motorcycle, invalid carriage, light motor vehicle, or heavy passenger. Thus, the newly incorporated expression transport vehicle into 10(2)(e) would include only the vehicles of the category as defined in section 216, heavy goods vehicle, 217, heavy passengers motor vehicle, sections 223, medium goods vehicle, and section 224, medium passengers transport vehicle, and would not include the light motor vehicle, which means transport vehicle also of the weight specified in section 221. Form 4 has led to some of the divergent views of this court, which was prevalent before 28/3/2001, prescribed under Rule 14 of the Central Motor Vehicles Rules, hereinafter referred to as the rules. The relevant portion is extracted here and below. Well, all these categories I had shown to your lordships and lords. At page 75, the form is set out. The aforesaid form, para 20, the aforesaid form was in vogue till 28/3/2001, in spite of the amendment made in the year 1994, deleting sections 10(e) to h. The form in which application was required to be made was not changed and came to be changed only in the year 2001 so as to carry out the effect of the amendment. The relevant extract of the amended form, as amended on 28/3/2001, by which the expression transport vehicle has been inserted, is extracted here and below, and this is the amendment. Your lordships were pleased to see this form earlier. Para 21. Though Form 4 has undergone other changes with respect to item A, motorcycle without gear, same is not relevant for our purpose. Form 4 makes it apparent that light motor vehicle is a description of the kind of vehicle as defined in section 221. A transport vehicle of a light motor vehicle category is not at all excluded in the form. Even otherwise, the form cannot control the substantive provisions carved out in section 10(2)(d) and 10(2)(e). The interpretation of the form is also to be in tune with the statements of objects and reasons and the provisions of the Act inserted by virtue of the amendment. Though it appears that in the amended form, medium passenger motor vehicle remains, that appears to be more due to oversight. Thus, as intended, the simplification of the procedures and policy liberalization has taken place by introducing in the form category of transport vehicle instead of medium goods vehicle, medium passenger motor vehicle, heavy goods vehicle, and heavy passengers motor vehicle. The policy of liberalization became necessary with an introduction of newer types of vehicle and fast increasing number of both personal and commercial vehicles in the country. In case it was intended to take transport vehicle out of the category of the light motor vehicle, then it was necessary to amend section 221 and section 10(2)(d) also, which has not been done. Thus, the intendment of the amendment has to be taken by addition of transport vehicle of the aforesaid categories of medium and heavy vehicles only, so that a person is required to apply for license only once to drive aforesaid 4 kinds of vehicle as per the amended provision of section 10(2)(e) and the form. Our aforesaid conclusion is also fortified by the inclusion of Rule 8 of 1989 rule, which provides for minimum educational qualification for driving transport vehicle to be 8th standard. The provisor to the rule makes it clear that the said qualification shall not apply in the case of renewal of driving license to drive a transport vehicle and or addition of another class of transport vehicle to the driving license already obtained before commencement of the Motor Vehicle Act 2007. Amended Rule 8 as inserted in 2007 is quoted below. minimum educational qualification for driving transport vehicle. The minimum educational qualification in respect of an applicant for obtaining a license to drive a transport vehicle shall be a pass in the 8th standard, provided that the minimum educational qualification specified in this rule shall not apply in the case of a renewal of a driving license to drive a transport vehicle or addition of another class of transport vehicle to the driving license already held before the commencement of the motor vehicle. The backdrop history indicates that the earlier aforesaid rule existed. It was omitted in 89. It had been reinserted in 2009. Rule 8 contemplates that in addition to transport vehicle of another category and the existing one in license, in 2007, the existing category of transport vehicle could only be light motor vehicle in section 10(2)(d), and another category of transport vehicle to be added is only as the amended provision in section 10(2)(e). Rule 8 refers to the addition of transport vehicle to light motor vehicle category. Otherwise, no purpose would be left behind insertion of Rule 8 again in 2007 in case transport vehicles of all categories are read into section 10(2)(e). Rule 8 also unambiguously lends support to the legislative intentment behind section 10(2)(e). Any other interpretation would make it redundant. Rule and exercise in futility is not undertaken by legislation. I may request your lordships to pause here and please consider this Rule 8 which is mentioned, because we have not seen this part, my lords. This is when a rule is reintroduced. It says that for renewal of a driving license to drive a transport vehicle, you are not required to be passing of 8th standard. That means, my lords, it would not have been possible for those who are already held without this qualification to be there for 8th standard pass to then complete their education and then apply for renewal.
Let's read that again.
Yes, my lord. Please see. Minimum educational qualification for driving transport vehicle. It's introduced on 10/4/2007. Is quoted below. Minimum education. The minimum educational qualification in respect of an applicant for obtaining a license to drive a transport vehicle shall be a pass in the 8th standard, provided that the minimum educational qualification specified in this rule shall not apply in the case of renewal of a driving license to drive a transport vehicle or addition of another class of transport vehicle to the driving license. So since it's introduced in 2007 again, and I was already holding it without this requirement of being 8th class pass, so the legislature found it fit to say that if you are renewing it, you don't have to then go and complete 8th standard and then come back, because that would have been the requirement otherwise. So the legislature clarified that for this purpose, as far as renewal is concerned or adding a class, you don't have to go back to school and complete 8th standard and then come back, which you were doing till hitherto, because it came right in the middle of by way of amendment to those who are already holding. But if you were applying for a transport license in 2007, then the requirement was that you ought to have completed the till 8th standard education. And now, my lord, this is no longer valid again, because my junior rightly informs me that this is omitted again in 2019. So the interpretation that is given in this judgment, my lords, may not be correct in my respectful submission, because 8 does not help that this part, my lords, at 78, that about third line from below, my lords, Rule 8 also unambiguously lends support to the legislative intent behind section 10(2)(e). Any other interpretation would make it redundant rule. An exercise in futility is not undertaken by the legislature, my lords. With great respect, the exercise undertaken by the legislature was a correct one. It protected those who already held a transport license, not to then go and get that other requirement, because it would have been very difficult for them. Driving license, para 24, my lords. Driving license is issued in Form 6 as provided in Rule 16 of 1989 rules. Form 6 is extracted here in below, my lords. This was also placed at page 79. A motor vehicles of the following description, etc. Driving license to drive a motor vehicle other than a transport vehicle. That's after the categories that is mentioned. This, your lordships has seen this with the space of endorsement. Then at para 25 is the opinion expressed by your lordships, my lords. Form 6 provides for light motor vehicle and transport vehicle separately. Though the form contains separate validity period for a motor vehicle other than transport vehicle, the aforesaid form and period of validity have to be understood in the light of the aforesaid discussion made by us of the light motor vehicle and transport vehicle. the form cannot govern the interpretation of the provision of sections 10 to D and 10 to E. Otherwise, also form has to be interpreted harmoniously with the Act and cannot be in conflict with the statutory provisions. The provision of the light motor vehicle has to be given full effect, and it is enjoined upon authorities to issue license in terms of the discussion made by us in the order, and validity period has to be construed accordingly. The validity period of transport vehicle of light motor vehicle license, which means the vehicle as defined under section in 221, has to be the same as that of other light motor vehicle of non-transport category, and there cannot be any distinction made with respect to the validity period of the class of light motor vehicle. The separate prescription for the validity of transport vehicle in Form 6 is only to take care of the provisions inserted in sections 10 to E. By deleting the provisions in sections 10 to E to H, it would apply to those categories. So this form also, my lords, again, it has been omitted in 2019 and been replaced, my lords, by what I showed to your lordships, my lords, where the photograph and the form with driving NR, NT and NR and NT and TR categories, my lords. So the forms part, because they keep changing, my lords, I'm skipping that part. Then at 82, my lords, right at the top, after going through another form, it is apparent that an application has to be made for addition of another class of vehicle. Light motor vehicle and transport vehicles are separately defined. Thus, it is clear that in the aforesaid form 4, 6 and 8, transport vehicle has to be understood in the category of vehicles for which provisions have been amended by sections 10 to E. The trade certificates dealt with section 34, I'm skipping the trade certificate part, Para 28, my lords, the aforesaid Rule 34 also makes a distinction between light motor vehicles, medium passenger motor vehicles, etc., heavy goods vehicle. For all types of vehicles, it is necessary that prototype of every motor vehicle qualify a test of the vehicle research and development establishment of the Ministry of Defence of the Government of India, Automotive Research Association of India as provided in Rule 126. The vehicle must conform to the provisions of the rules made under section 110. Relevant information has to be inserted as per 41. In the Act, and the registration particulars may be prescribed by the central government. Class of vehicles, gross vehicle weight, as well as unladen weight are required to be mentioned in the registration particulars in Form 20. The interpretation made by us is also supported by the syllabus which is prescribed for light motor vehicles and separately for medium and heavy vehicles driving practice. Rule 31 of the rules contains the syllabus for imparting instructions to the driving of motor vehicles in school and establishment. Syllabus is divided A to K. Your lordship saw this part, my lords. The question fell from your lordships, my lords, about this syllabus. It is on page 83, my lords. It is apparent from the aforesaid syllabus that no separate syllabus has been provided for transport vehicle. Transport vehicles have been included in the syllabus as per the class of vehicles. That is to say, syllabus of light motor vehicle would include the syllabus of transport vehicles of that class. The syllabus has been formulated as per the weight of the vehicle. I had shown to your lordships the syllabus. Your lordship saw that for transport vehicles, there is a special requirement. Sorry, just Para 30, my lords, the state government has to maintain a register of motor vehicles under Rule 75 as provided in Form 41, which includes gross vehicle weight, unladen weight, etc. Central government has the power to frame rules under Section 27, inter alia, regarding minimum qualification forms and contents of the license. Thus, we are of the considered opinion that the definition of light motor vehicle under 10 to 21 of the Act includes transport vehicle of the class and weight defined therein. The transport vehicle of omnibus would be light motor vehicle, gross vehicle weight of which, and also a motor car or tractor or road roller, unladen weight of which does not exceed 7,500 kgs and can be driven by holder of license to drive light motor vehicle, and no separate endorsement is required to drive such transport vehicle. It is settled proposition of law that while interpreting a legislative provision, the intention of the legislature, motive and philosophy of the relevant provision goes to be achieved by enacting the same have to be taken into consideration. Then the judgment sets out various principles of statutory interpretation, which your lordships are well aware of. As far as this is concerned, may I skip these parts, Lords, as the interpretation and the
Para
judgments?
39.
Yes, Lords. Para 39, then I'm obliged, Lords. Para 39, Lords, at page 86. From the aforesaid principles, it is apparent that plain and simple meaning has to be given to section 10(2). When the legislature has not amended the provision, we cannot rewrite the definition of section 221 of light motor vehicle and section 10(2)(d), and full effect has to be given to the omission which has been made in the provisions of section 10(2)(e) to h by substituting transport vehicle, and under 10(2)(e) and plain and literal interpretation of existing provision and amended provisions has to be made. When the legislature has not amended the aforesaid provision, it is not for the court to legislate by making insertions in section 10(2)(e). What has not been provided in the statute with a purpose cannot be supplied by the courts. The court has to construe provision and not act as legislature. In other words, interpretation suggested by the insurers would mean rewriting the provision, which is not permissible in the light of the aforesaid discussion. And your lordships may come to the various other judgments are there, my lords, and then 48. Then various other judgments, then the conflicting judgments, your lordships were pleased to set them out, my lords. And the final conclusion (3 50) 55, my lords, at page 100. Sections 10(2)(a) to j lay down the classes of vehicles to be driven, not a specific kind of motor vehicles in that class. If a vehicle falls into any of the categories, a license holder holding license to drive the class of vehicles can drive all vehicles of that particular class. No separate endorsement is to be obtained nor provided if the vehicles fall in any of the particular classes of section 2. This court has rightly observed in Nagashetty that in case submission to the contrary is accepted, then every time an owner of a private car who has license to drive a light motor vehicle attaches a roof carrier to his car or a trailer to his car and carries goods thereon, the light motor vehicle would become a transport vehicle and the owner would be deemed to have no license to drive that vehicle. It would lead to absurd results merely because a trailer is added either to a tractor or to a motor vehicle. It by itself does not mean the driver ceased to have valid driving license. In a considered opinion, even if such a vehicle is treated as transport vehicle of the light motor vehicle class, legal position would not change. The driver would still have a valid driving license to drive vehicle of a light motor vehicle class, whether it is transport vehicle or a private car tractor attached with trolley or used for carrying goods in the forms of transport vehicle. The ultimate conclusion in Nagashetty is correct, however, for the reasons as explained by us. And because there is for the tractor, etc. Para 58 at 102. Transport vehicle has been defined in section 247 of the Act to mean a public service vehicle, a goods carriage, an educational institution bus, or private service vehicle. Public service vehicle has been defined in 235 to mean any motor vehicle used or adapted to be used for the carriage of passengers for hire or reward and includes a maxi cab, motor cab, contract carriage, and stage carriage. Goods carriage, which is also a transport vehicle, is defined in section 214 to mean a motor vehicle constructed or adapted for use solely for the carriage of goods, or any motor vehicle not so constructed or adapted when used in the carriage of goods. It was rightly submitted that a person holding license to drive motor vehicle registered for private use who is driving a similar vehicle which is registered or insured for the purpose of carrying passengers for hire or reward would not require an endorsement as to drive transport vehicle, as the same is not contemplated by the provisions of the Act. It was also rightly contended that there are several vehicles which can be used for private as well as for carrying passengers for hire or reward. When a driver is authorized to drive a vehicle, he can drive it irrespective of the fact whether it was used for private purpose or purpose of hire or reward or for carrying the goods in the said vehicle. It is what is intended by the provisions of the Act and Amendment Act of 54 of 94. Section 10 of the Act requires a driver to hold a license with respect to class of vehicles and not with respect to the type of vehicle. In one class of vehicle, there may be different kinds of vehicle. If they fall in the same class of vehicle, no separate endorsement is required to drive such vehicles, as light motor vehicle includes transport vehicle. Also, a holder of light motor vehicle license can drive all the vehicles of the class, including transport vehicle. It was pre-amended position as well as post-amended provision of position of Form 4 as amended on 28/3/2001. Any other interpretation would be repugnant to the definition of light motor vehicle in Section 221 and the provisions of Section 10(2)(d). Rule 8 and 1989 rules. Other provisions are, and also the forms which are in tune with the provisions. Even otherwise, the forms never intended to exclude transport vehicle from the category of light motor vehicles. And for the light motor vehicles, the validity period of such license hold good and apply for transport vehicle and such class also. And the expression in Section 10(2)(e) of the Act, transport vehicle would include medium goods vehicle, medium passenger motor vehicle, heavy good vehicle, heavy passenger motor vehicle, which earlier found place in Section 10(2)(e) and H, and our conclusion is fortified by the syllabus and the rules we have discussed. Thus, we answer the questions which are referred to. Light motor vehicles, as defined in Section 221 of the Act, would include a transport vehicle as per the weight prescribed in Section 221, read with Section 215 and 248. Such transport vehicle are not excluded from the definition of light motor vehicle by virtue of Amendment Act 54 of 94. A transport vehicle and omnibus, the gross vehicle weight of either of which does not exceed 7,500 kilograms, would be a light motor vehicle, and also motor car or tractor or road roller, unladen weight of which does not exceed 7,500 kilograms. Holder of driving license to drive class of light motor vehicle as provided in Section 10(2)(d) is competent to drive a transport vehicle or omnibus.
He has given the associated.
This is all subject to learned friends' arguments. And
Fair enough. So,
only submission I would like to make is, my lords, if a new class is added as a transport vehicle, then all transport vehicles, wherever they are referred to, in the definition or otherwise in the, would then fall under for the purposes of the class which is included by a substitution. And then one can't go back and say, no, it is in LMV, so therefore don't include it here, which is the section which deals with for licensing purposes, read with Section 3. And as your lordship saw, section 3 is only referred to, but not dealt with otherwise. Why is there a separate, the second part of section 3 is specifically not dealt with, that and for a transport vehicle, you require that qualification. I'm deeply obliged.
Thank you, Mr. Dave. Thank you. Yes, Mr. Bhushan.
But your lordship has seen the
judgment is the most tedious part in the whole.
issue really arises because of the definition of light motor vehicle, which includes a transport vehicle which is under 7,500 kilos. And therefore, that is the basis on which Lord Mukul Devangan has held that once you have a license for a light motor vehicle, that includes a transport vehicle of less than 7,500 kilos. Now, Lord Mukul Devangan has made a mistake in two crucial aspects. One is in dealing with section 3. Just have a look at section 3. And this section 3 was there, my lord, before the 1994 amendment. Before transport vehicle was added in section 10(2). So even when there was no specific category of transport vehicle in the kinds of licenses you could get in section 10, section 3 was still there. And this is how it reads.
1 second. Let's get back to it for a second.
Yes.
What is the page?
319.
319.
319.
Yeah.
No person shall drive a motor vehicle in any public place unless he holds an effective driving license issued to him, authorizing him to drive the vehicle. Now pause here for a moment. If it was only till there, my lord, I could have understood that you could have said that light motor vehicle includes a transport vehicle. Therefore, if you have a transport vehicle of less than 7,500 kilos, a license authorizing you to drive a light motor vehicle authorizes you to drive a transport vehicle of less than 7,500 kilos. But it goes on further. And no person shall so drive a transport vehicle other than a motor cab or motorcycle. I'll come back to this motor cab, why this is excluded. Hired for his own use or rented under any other scheme made under subsection 2 of section 75, unless his driving license specifically entitles him so to do. Now, what is the meaning, my lord, of the second part? And no person shall so drive a transport vehicle. It clearly means that whatever your license, whether transport vehicle is included or not, but you cannot use that license to drive a transport vehicle unless your license specifically authorizes you to drive a transport vehicle. It's absolutely clear. I mean, it could not be more specific than this. What was the need of having the second part? If you were to say that no, light motor vehicle includes a transport vehicle of less than 7,500, and therefore, if you have a license to drive a light motor vehicle, you can drive a transport vehicle, even if your license doesn't specifically authorize you to do so. Then, my lord, the second part becomes otiose, it becomes totally redundant. Just excise it from that section for a moment and see the result is the same as what Mukul Devangan says it is. If Mukul Devangan is right, that merely because the definition of light motor vehicle includes a light transport vehicle, therefore, under section 3 it can be driven, what was the need to add, my lord, the second part? those lines become totally redundant if the my lord, the interpretation given by Mukul Devangan is accepted. And it's an accepted principle of law, my lord, that you cannot give any interpretation to any provision which makes certain words redundant.
Yes.
But may I immediately cite that judgment? It's a Constitution Bench judgment. Of course, there are several, but I'll cite only one. 2005, I've given a compilation of judgments in the morning.
That no part of a statute should be rendered redundant.
Correct.
Yeah, that's very clear. Just give us a
Absolutely right.
citation,
So
that's
just
all in the
that-
para.
Your Lordship may just note, my lord, 2005, 2 SAC, 271, paragraph 14.
What is the name?
It's called, my lord, Nathi Devi versus Radha Devi Gupta, and relies upon several other judgments which are mentioned in it, but I took out only one because it's Constitution Bench. I'll just read that one, paragraph 14. I'd given that compilation
Yes,
of
we got it
judgments
here. We got it here.
if it can be shared.
Yes, they're sharing it.
14.
Para 14.
Page 64 of the compilation, the running
Yes, we
page.
got it here.
Yes. It is equally well settled that in interpreting a statute, effort should be made to give effect to each and every word used by the legislature. The courts always presume that the legislature inserted every part thereof for a purpose, and the legislative intention is that every part of the statute should have effect. A construction which attributes redundancy to the legislature will not be accepted except for compelling reasons such as obvious drafting errors. See State of UP versus so and so, so and so, so and so. That's a well accepted principle. Now, Lord, what I am submitting before your Lordship is, just see Mukul Devangan now. How it interprets, my lord, the section 3, how it deals with the section 3 is only in this one paragraph, that is paragraph 17. Page 74 of Mr. Dave's compilation. Your Lordship has placetum C, just one line below that. The provision of section 3 of the Act requires that the person, in order to drive a transport vehicle, must have authorization. Once a license is issued to drive light motor vehicle, it would also mean specific authorization to drive a transport vehicle or omnibus, the gross vehicle weight, or motor car, road roller, or tractor, the unladen weight of which, as the case may be, does not exceed 7,500 kilograms. This is how, my lord, this section 3, the second part, is dealt with. This, in my humble submission, is totally wrong. It is not a specific authorization to drive a transport vehicle. A license to drive a light motor vehicle is not a specific authorization. And this ignores this principle that in interpreting that, you cannot make any sentence of that otiose or redundant. If this is the correct interpretation, then, my lord, that second part, and no person shall so drive a transport vehicle, becomes absolutely redundant. If you remove it, this is the same interpretation, my lord, that will be given. Namely, if the light motor vehicle includes a transport vehicle, you will be authorized to drive it.
How do you
They really
interpret?
go by the definition of light motor vehicle.
Yes.
That first sentence of para 17, the definition of light motor vehicle
Yes.
makes it clear that for a transport vehicle or omnibus, the gross vehicle weight or either of which, or a motor car or tractor or road roller, the unladen weight of any of which does not exceed 7,500. That sentence is incomplete actually, but no change has been made by the amending act of 94 in sections 221 and 10(2)(d). The definition of light motor vehicle has to be given full effect to, and it has to be read with 10(2)(d), which makes it abundantly clear that light motor vehicle is also a transport vehicle. The gross vehicle weight or unladen weight of which does not exceed 7,500.
Therefore, my lord, this judgment goes purely by the definition. That only because the definition includes a transport vehicle, therefore, your license to drive a light motor vehicle includes a transport vehicle, but that totally,
How do you want the definition to be interpreted?
not the definition is for various
221.
other purposes
According
as
to you,
well.
how-
The definition, so therefore, the definition clause always says, unless the context otherwise requires. And therefore, my lord, it cannot be, this definition cannot be used for the purpose of section 3.1, particularly where the second part of section 3.1 says, and no person shall so drive a transport vehicle unless his driving license specifically entitles him to do so. What is the meaning to be given to the second part if not this judgment is correct? That you go only purely by the definition. Light motor vehicle includes transport vehicle. Therefore, a license to drive a light motor vehicle includes a license to drive a transport vehicle. Then what happens to the second part? What does specifically mean? Unless his driving license specifically entitles him so to do. And which is why your lordship sees the form specifically says authorization to drive a transport vehicle. Just see not that form that is quoted actually in this judgment. Your lordship has page 685 of the judgment. Sorry. Page 121. This one now, of course, it has become a lot. Your lordship has seen the license.
word as defined.
If you have a license to drive a light motor vehicle, how is there a specific authorization to drive a transport vehicle? And that specific authorization was provided along the form.
The expression transport vehicle under 21, 221 may not be used in the same manner as is defined in the section. It might have been a general usage. Unless we see the original position as it were. 1959 Act, is it? Before this? 1959. 39.
See, one thing is very clear that
Yes.
a light motor vehicle includes a class which is wider than a transport vehicle,
Correct.
right?
Correct.
Because otherwise, light motor vehicle would be equated with a transport vehicle. Now, if you go back to section 221 at page 317 of Mr. Dave's compilation,
Means a transport vehicle
like light motor vehicle means a transport vehicle
or omnibus.
Omnibus is a vehicle which is so adapted to carry more than 6 passengers.
Correct.
The gross vehicle
Or a
weight,
motor car.
right? Or yes,
Or a motor car.
or omnibus, the gross vehicle weight of either which or a motor car or tractor or road roller. The unladen weight of which does not exceed 7,500
Correct.
kilograms.
So therefore,
So the expression transport vehicle in 221, is it to be read in the context of the definition of transport vehicle in 247?
47.
yes, I would say yes, except that it is qualified by that it should not exceed 7,500 kilograms. So all transport vehicles which are less than 7,500 kilograms would come under the definition of light motor vehicle under 221.
Where the gross vehicle weight is less than
Yes,
7,500.
yes. But that doesn't mean that if you have a license for driving a light motor vehicle, that gives you authorization to drive a transport vehicle less than 7,500 kilos. Why? Because section 3, which authorizes you to drive what kind of vehicle, namely whatever your license describes it as, has a proviso, or a sort of a proviso. But if you are going to drive a transport vehicle, then your license must specifically authorize you to do it.
Because the words, according to you, specifically entitles
Yes.
him so to do.
Yes.
These are words of some significance in the sense that otherwise, everybody who holds A light motor vehicle license would be entitled to drive a transport
Correct.
vehicle.
Any of them, not only.
Now, supposing,
Unless
for
his driving
instance,
license specifically entitled. This also seems to indicate that the licensing regime is different from, just the definition
absolutely
regime.
right. And your lordship has seen, my lord, the form of license. There is a now, of course, my lord, under the amended rules, 2021 amendment, it says light motor vehicle transport or non-transport. So that makes it absolutely clear, but that has come only in 2021. The form earlier, when Mukund Devangan was there, also had, my lord, just have a look at Mukund Devangan itself. The form is given at page 685 of the judgment, which is not 121 of Mr. Dave's compilation. In para 24, that form is given. Sorry, 121 of our, just look up Mr. Dave's compilation. Yes, your lordship
And
has
Justice
not.
Mishra's judgment holds that in section 10, the words transport vehicle were introduced on 14th November 1994.
Correct.
And all those other categories were also deleted. F,
Yes.
G, and H were
Yes.
deleted.
I'll come to that as to what is the effect,
he
my lord,
says,
of that
the learned
amendment.
judge says that the mere addition of the word transport vehicle in 1994
Yes.
does not obliterate the fact that yet a light motor vehicle is included.
So
A transport vehicle is
for the
included in
moment,
the definition
I
of
am
the
for
light
the
motor.
moment, my lord, addressing your lordship
On
on
three.
what would have been the position prior to the amendment, even prior to the amendment, before transport vehicle was added as a separate, my lord, class under section 10. I am saying that even before 1994, my lord, because of section 3, which specifically said, had an exclusion that if you want to drive a transport vehicle, you can't go just by the categorization of the license. It must specifically authorize you to drive a transport vehicle.
And the
which
principle in
is why, my
section
lord.
3, the principle in section 3, which is so very clear, is completely reflected in the entirety of the scheme of the
Absolutely
statute,
right, because there is a
which
separate.
draws out very, very clear distinction
Absolutely right.
between transport and non-transport vehicles.
Supposing I get a LMB
Requirements
license
of
at
the
age
license
18.
are different. Medical certificate requirements are different.
Age is
Renewal, age.
The very fact that if I cannot get a license to drive a transport vehicle unless I've had a license to, I can't even get a learner's license to drive a transport vehicle unless I've had a license to drive an LMV for 1 year. Now, supposing, my lord, how is this judgment going to, my lord, reconcile all this? I get a LMV license at age 18, and according to that, my lord,
Actually, if the construction which was placed by the court was right, then these words had no reason. The legislature had no reason
Absolutely.
to introduce these
The
words
second part.
in the second part.
Absolutely right.
Not only the, sorry,
Because then the first part would have been adequate. No person shall
Exactly.
drive a motor vehicle in any public place unless he holds an effective driving license issued to
Exactly.
him authorizing him to drive the vehicle.
And that is why I cited that.
The second part
constitutional
was
bench.
brought in specifically to cover only transport vehicles.
Right.
or
So
else
that
it's
renders
also-
that totally redundant.
That's Osho's otherwise, that second part.
it actually collapses the two separate features of the statute into one. So it's actually the section 3's bifurcation becomes redundant,
Absolutely.
and also half of the statute becomes redundant.
Correct. How do you, I can get a license at 18.
I've seen.
Yes.
What
Now,
else is?
my second point is post.
Just one.
So, my Lord, the position would be covered by section 3, and that is dehors the 1994
So that is your
amendment.
first
First
reason
point.
why you say
Right,
that's
right.
wrong. Now, what is the second reason why it is wrong?
Second reason, my Lord, is post 1994, when in section 10.2, E to H were deleted and E became transport vehicle. Now you have a separate category in the form of the license itself, namely transport vehicle. My submission is that the principle of generalia specialibus non derogant, or, my Lord, the equivalent principle generalibus specialia derogant, the first of which means, my Lord, that general things do not derogate from special things. The second of which is more important, is that special things derogate from general things.
What is the second Latin word?
It's generalibus specialia derogant. The principle is that if you have a specific or a special entry or a word, as against that you have a general, then whatever comes within the ambit of the special will be excluded from the general. Now, Lord, in this case, 10.2 now has a category of transport vehicle, which is specific. It also has the category of light motor vehicle, which is general, which may have a private motor car, a light transport vehicle, a road roller, an omnibus, etc., various things. That's general. Now, if you need to have a license to drive a transport vehicle, my submission is that you will fit into the special part of 10.2, which is the transport vehicle, and not be covered by the general. The general will exclude something which is specifically provided separately. I'm not citing another Constitution bench judgment for this proposition. There are several. That is 1979 3 SCC 347. It's called State of Gujarat versus Patel Ramji Bhai Dana Bhai. Constitution bench headed by Chief Justice Chandrachud, the senior. And I'll just take your lordship to a few paragraphs. Paragraph 3 first. Paragraph 3, my lord, of this judgment. The common question posed for our decision in all these appeals is whether any of the provisions in sections 33(6) and 35 of the Bombay Sales Tax Act, which are in para materia with section so and so of the Bombay Sales Tax Act 1953, the earlier act, offend Article 14 of the Constitution, and as such are void. The High Courts, tribunals, and the concerned appeals have answered this question in the affirmative, namely saying that it's arbitrary because you can invoke either of the two sections for a particular class of cases. Your Lordship may have paragraph 12. By a common judgment, dated 8th July 1970, the Gujarat High Court held that the provisions of Section 33(6) and 35 overlap each other because all cases of escapement of assessment by a dealer can be dealt with at the sweet will of the assessing authority. Under either of these provisions, that a dealer who is subjected to the procedure provided in Sections 33(6) will find it more onerous than the one in Section 35, inasmuch as unlike the latter section, no period of limitation has been provided for taking action under Section 33(6). No guidelines have been provided, and the choice of one procedure in preference to the other is left to the arbitrary whim of the assessing authority. On this reasoning, the High Court held that Section 33(6) offends Article 14 of the Constitution.
This was that old line of authority, Northern India caterer, that when
Absolutely,
there is a more rigorous
sort.
procedure and a general procedure, then
And-
that violates Article 14.
And you
then,
have
of
a
course, it
choice
was
of
overruled.
going to
68
either
was
or.
overruled in 74.
Correct.
Yeah.
Your Lordship may then have paragraph 23 where the sections are set out.
How did they actually formulate it? Let's see how they formulate it. Just
relevant
shows of just a relevant
Principle, right?
formulation,
The
the
principle.
principle.
Yes. But just have paragraph 26. In fact, 25. An analysis of sections 33(6) of the 1959 Act corresponding to section 14(6) of the 1953 Act will show that it applies to that particular class of dealers liable to pay tax who, 1, fail to apply for registration as required by law, and 2, fail to pay the tax in respect of any period. Thus, 33(6) is in terms restricted in its application to the case of unregistered dealer whose modus operandi to evade tax involves ab initio disregard of the law. It does not apply to a registered dealer who has escaped assessment or has been under-assessed or assessed at a lower rate, or has been wrongly allowed any deductions, or has concealed any material particulars relating to sales or purchases, or has knowingly furnished incorrect
Yes,
returns.
got it. Yeah. Yes, Mr. Bhushan, we've seen that.
Go to the next.
We'll go to the next.
So then it goes on to cite the principle.
So according to you, transport vehicles were brought in by amendment in 1994.
Correct.
Therefore, the general category of light motor vehicles would necessarily therefore have to be construed as excluding transport
vehicles. Because if you want to drive a transport
And
vehicle,
the definition is always unless something to the contrary appears in the text
Right,
of the statute.
right. So this is totally not apart from the section.
That's the second reason why you have said that.
That's the second reason.
What is the next point now?
Now, Lord, the reason for exclusion of transport vehicles from the license to drive an LMV, that you need a specific authorization, what is the reason? I mean, why have they done this? Please have a look at what transport vehicles are. See the definition. (247), page 318. And not just to sort of continue with the last one about that 10(2), the special and general. Mukul Devangan deals with it by saying that 4 categories were removed and transport vehicle was added. That is medium, passenger and goods, heavy, passenger and good. These were the 4 which were removed and transport was added. Therefore, my Lord, Mukul Devangan says, therefore the entry transport vehicle there would be deemed to be only medium or heavy transport vehicles, because you have replaced those 4 with transport vehicle. Those have been deleted and transport vehicle has been added. Therefore, it will be deemed that transport vehicle as added in 10(2)E now will only be medium or heavy.
Those which were excluded.
Those which were excluded. Now, Lord, it doesn't say, the entry doesn't say transport vehicles other than light motor vehicles. It just has transport vehicles, all kinds. Now, merely because 4 were excluded.
That's the point.
You have to tell us the
Yes, 247.
reason for excluding.
Correct. transport vehicle means a public service vehicle, a goods carriage, an educational institution bus, or a private service vehicle. Now just see the definition of public service vehicle, which is lot 35. Just before this. Means any motor vehicle used or adapted to be used for the carriage of passengers for hire or reward, and includes a maxi cab, a motor cab, transport carriage, and stage carriage. So you're carrying passengers. Normally, in a private car, you're carrying yourself and people who know you, and therefore who can trust you. But here you're carrying passengers who don't know you. You may be driving a bus, you may be driving a school bus. And therefore, people, strangers to you, are putting their lives in your control. And therefore, a lot of the licensing provisions are much more stringent. Get a license, you must be at least 20, you must have that kind of
Yes.
maturity. The license will be given only for 5 years, it will have to be renewed every 5 years. Unlike not a light motor vehicle, which will be valid up to 40, it could be valid for 22 years. You get it at 18. You have to have a medical examination and a certificate before you get a license, unlike modern light motor vehicle.
Yes.
So why is all that? Why is there a stringent blood mechanism for transport vehicles? Because you are putting others at risk. Or in the case of goods vehicles, because it also includes not goods vehicles, you are driving normally for very long hours. Truck drivers drive for very long hours. So again, that's according to me, the rationale for having a totally different regime for licensing of transport vehicles, or for granting a license enabling you to drive a transport vehicle. Now, just come back to 3.1, which is why certain kinds of transport vehicles are excluded from that specific authorization. And no person shall so drive a transport vehicle other than a motor cab or motorcycle hired for his own use. So a motor cab may be a transport vehicle, but if you hire it for your own use, then you're not putting others at risk. Motor cab is a transport vehicle. Your Lordship may have a look at, my Lord. The definition of motor cab means any motor vehicle constructed or adapted to carry not more than 6 passengers, excluding the driver, for hire or reward. So you may hire a car, but you want to drive it yourself.
Excluding the driver for hire.
Correct. So why is this exclusion from transport vehicle? Because you're not putting others at risk.
When you use your personal car as a Ola.
Correct. No, the reverse. When you use a rented vehicle, when you use your personal car as an Ola, then you have to get a transport vehicle license. Absolutely right. But when you use a rented car for your own use, then you don't need a transport
You're not
vehicle
carrying
license.
outside.
You don't need to.
Yes, absolutely right. So that is, my Lord, my third point, namely that's the rationale for having a separate regime, separate syllabus, separate age, separate validity of license, medical certificate, all those provisions which my learned friend pointed out, my Lord. And how do you reconcile the two? Supposing this judgment was right, each and every one of them you'll have a problem. I can get a LMV license without, my Lord, a medical certificate. And then I can, according to the judgment, I can then drive a transport vehicle with it. But the section says you cannot get a transport vehicle license. You can't drive a transport vehicle unless you do all this. You get a medical certificate. I can get a license at 18. I don't need to renew it, my Lord, till I'm 40. How do you reconcile all this? It doesn't say that if your LMV is license is going to be used for transport vehicle, then you must get it renewed every so many years. My license will only say LMV. And according to this judgment, I can drive a transport vehicle with it, provided it's under 7,500 kilos. Then, my lord, I don't need to get it renewed every 5 years, despite the provision. I can drive it at 18. I can get a license without a driver's license. How do I, my lord? If the provision says you can get a learner's license for a transport vehicle only if you've had a license, a real proper license for a LNV for 1 year. But in the same breath, this judgment is saying if I have an LNV license, I can drive a transport vehicle. All these will become contradictory, all these sections. There is a section 9(4). I'm unclear, Lord, as to whether your lordship had seen it earlier. Just have a look at that also.
Can we come back at
Yes.
2 o'clock?
Lordship, please.